to those proceedings and the papers. So
yes, I'm not having that debate with you.
No,
I know that's what the rules say,
Exactly.
and we have used the rules.
Exactly.
What I'm struggling with, or what I don't see,
Yes.
is how that gets to be applied, or how your client relies on that,
Yes.
given what he has
Yes.
set out in the
And
papers.
that's why I started by clarifying, by saying if you want that direct explanation in the affidavit, I have to accept it's not there. But why the Schedule A is attached to the notice of motion is because it's one of the prayers that are sought from the Commission applying the Commission and the Chairperson applying his mind. If on the basis of no pleading, the Commission says, well, I can't grant you that relief because you haven't made out a case for that, then I have to accept that. But the reasonable explanation as to why there's an attempt not only to keep this application in camera, but limit who has access to the content of the application is threefold. Number one, Mr. Karim nor his legal team knows the internal processes of the Commission. And it might be the case that not everybody in the Commission needs to be involved in the Mr. Karim specific matters. And so the Commission might in and of itself have its own Chinese walls that it will sometimes enforce or not enforce in order to preserve the integrity of whatever's happening in front of the Commission, which I say applies here in an in-camera request. Number two is that never mind whatever the Commission's own internal processes are, practically speaking, in the light where the Commission, where the case made in front of the Commission is that I'm being surveilled, I am under threat, I don't know who's watching me or who's not watching me. At its most generous interpretation from Mr. Karim's side, obviously there's a less generous interpretation from the case against me, but the most generous interpretation that can be afforded to Mr. Karim is that that Schedule A, which was subject to the control of the chairperson of the Commission at all times, was an attempt to make sure that the net was not cast too widely so that all and sundry, and I'm using that phrase again, but I'm using it with respect, get access to the very papers that may or may not result in the breach or of Mr. Karim's rights in the way that he's saying in the papers. The third explanation, Commissioner Baloy...
The second explanation, put simply, is he doesn't trust the rest of the staff of the Commission that they may not distribute. Or in fact, he doesn't trust the Commission. He has to leave with a list in Schedule A, but he doesn't trust the beyond that.
I hope that the correspondence bundle has been placed in front of the Commission, because what you will see from the correspondence bundle is that my client has consistently complained about inconsistent treatment, about the Commission's inconsistent application of its own rules, and the prejudice that he has suffered as a result of the Commission's conduct towards him.
Is your answer to my question that, is it a yes? He doesn't trust that the Commission will not share his application outside of the Commission, that with the consequence that those who are threatening him would become aware of it. Is it a yes to my question?
It is a yes, but okay. I hope you will understand, Commissioner Baloy, that it's not an out-and-out yes in the sense that, you know, my client is complaining about that this is just a farce exercise or that he won't get a fair trial. It's based on his experience at the hands of the Commission that that lack of trust arises. And I'm being very guarded in my language in making that point, because that implicates potentially not only my learned friend, the other evidence leaders and the staff of the Commission, of which there are many and they are unknown to me. And I don't want to trample upon the integrity of my colleagues, whom I have known and have no difficulties or issues with. It's just that obviously my client, given the treatment that he has been subjected to, has a legitimate concern which informs the application and the attempt to limit the access as explained in Schedule A.
Just to be clear, that treatment that he's complaining about and on which he suggests he relies for seeking to limit who has access to his papers, does it include a disclosure of whatever he submitted to the Commission to the public?
does it involve breaches of confidentiality? That's the substance.
Well, it's difficult in the facts to answer that in circumstances where we only gave the statement yesterday. No, not yesterday, 2 days ago on the 4th at 9. The statement hasn't become public, which we're grateful for, but you'll remember that the only time we received the direction from the Commission that that statement was going to be kept confidential was when we received the directive, I think it's paragraph 6 or 7, that unequivocally states that whilst the in-camera is being fought over, the main statement will be subject to the in-camera treatment. So obviously, as a result of that directive, that remedies the concern of my client to some extent, as we sit here now, but it certainly animated my client's concerns prior to the handing down of that directive.
I guess what I want to do, Mr. Pramito, what I want to get out of you is it has to be clear that whatever your client's complaint is about the treatment he's received from the Commission, it does not include a complaint that the Commission has disclosed what he asked to be confidential matter. It has been disclosed to the public. I think it is important for our processes.
Yes.
That is clarified.
That's
not what you are complaining about.
No, that's right. But if you have regard to the correspondence bundle, Commissioner Baloy, you will recall that that around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
But Mr. Karim can't make his own rules.
No.
There was, from where the Commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is
that.
actually totally unacceptable, Mr. Premier.
With all due
He
respect,
cannot, Mr. Karim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD is not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the Commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
yes.
but with all due respect, Chair, on the 18th of February, which is the date that the application was launched, the following was said in that covering letter. And this is why we're having a debate which is slightly removed from the facts, with all due respect. The request was made.
I'm very sorry, I intervened.
Oh, sorry, I apologize. May I
I intervened twice, my colleague was still asking you. Yes, please go on.
May I
Premier.
respond to you, and then Commissioner Baloy, subject to the Chair's authority, of course, if you can re-put your question to me, because I'm now dealing with what the Chair says.
Yes,
I apologize for that. But Chair, it's very important because when the application was launched, what was explicitly raised with the Commission staff and the evidence leaders is a request that this entire application would be disposed of. This very in-camera application that we are asking for today would be disposed of by the 25th of February, which was before the statement was due, so that my client would know what his position was come the 27th regarding the filing of the statement and whether that was going to be in camera and then the hearing was going to be in camera or not in camera, because obviously the determination of the in camera might have also triggered my client's request to file a confidential affidavit with the Commission. And so on the 18th of February, my client doesn't only say, please bring this to the extremely urgent attention of the Chair so that a determination is made by the 25th before our statement is due. He says you can even dispose of this entire matter on the papers. We don't need an oral hearing because this is an extremely urgent matter. The issues are fairly narrow and we want an expeditious outcome. come so that we know what our client's position is. And with all due respect, what happens on the 18th of February from the Commission, we get a one-line email saying, we confirm that same is in reference to the application, will be relayed to the Secretary and the evidence leader shortly, and we will revert with formal instructions in due course. Nothing is heard from the Commission from the 18th, 19th, 20th, 21st, 22nd, 5 days. And now you must remember, of course, that the statement deadline is coming nearer and nearer. And what we then do on the 23rd is we write to the Commission on the 23rd to say, please can you advise us what the delay is, because our statement deadline is approaching. We might be wrong in the way that the chairperson puts it to me, that it's not for Mr. Karim to determine, but we need some clarity from the Commission, the chair in particular, as to what the next steps are here. And so, with all due respect, Chair, when I talk about these threats emanating, it's not as though my client had, by the time his statement fallen due, not only launched an application where formal relief was sought in respect of the delivery of that statement, correspondence was repeatedly sent to the Commission staff and the attorneys asking that this matter be dealt with extremely urgently and in an expedited fashion. And my client also waived with respect the very right to a hearing that we are having here, because he wanted to know what his position was by the 25th so as to what to do on the 27th. And where I say that those threats from the Commission are unconscionable, and with all due respect, I speak subject to the chair putting me back in order if I'm out of order, is that the Commission in its subsequent letters after the 27th don't even engage with the fact that it's due to them that the entire matter hasn't been disposed of on the timetable that might have been extremely urgent for understandable reasons, but where we had asked for a ruling. So why I'm saying that those threats are unreasonable in the circumstances is not because it was Mr. Karim acting of his own accord. It was Mr. Karim at every stage saying to the Commission, place this in front of the Commissioners, get me a determination by the 25th so I know what to do by the 27th. And when the 27th came and went, we hadn't heard anything. We only received the answering affidavit on the 24th. So, Chair, with all due respect, I hear what you say to me, and I hear your admonition regarding what I said about the Commission's threats, but there's a factual context that's important to bear in mind as well, and that is that Mr. Karim sought the assistance of the Commission